All right, today we're jumping into a really fascinating and honestly, a deeply divided case from the Supreme Court of Canada. It's a classic story, the power of the police versus the rights of a young, vulnerable suspect. And it all boils down to one thing a murder confession that, well, might not have been as voluntary as everyone thought.
And that really is the heart of the matter here, isn't it? It's the central question we're going to tackle. Police can say, hey, you're free to go, or this is just a voluntary chat, but think about it. If you're 19 years old and you're surrounded by armed officers, what does voluntary really mean in that moment? So to get our heads around this, we've got to talk about the person right in the middle of it all. A young man named Nigel Lafrance. Back in 2015, he's just 19, fresh out of high school, and suddenly he finds himself as the main suspect in a murder investigation. This all leads to a confession that ends up being debated at the highest court in the entire country. Okay, so who was Nigel Lafrance? And listen, these details here, they're not just, background filler. They're absolutely crucial to the story. We're talking about a 19-year-old who was Indigenous, had basically zero experience with the police or the justice system, and on top of that, was physically much smaller than the officers. So this isn't just about who he was, it's about the massive power imbalance that was there from the very start.
So let's just quickly run through the timeline so we're all on the same page. A man named Anthony Asinski is killed on March 17th. Literally 2 days later, boom, police are at Lafrance's home. That's our first pick event. Fast forward about 3 weeks, he's arrested, interrogated, and that's when he confesses. And get this, it took a whole 7 years for this case to wind its way up to the Supreme Court for a final decision.
Okay, let's zoom in on that first interview, the one on March 19th, because how this all started is so important. We're talking about a 6:50 a.m. visit. This was not a, hey, can we ask you a few questions kind of thing? It started with a search warrant before the sun was even up. That sets a pretty intimidating tone right from the get-go, don't you think?
Seriously, try to put yourself in his shoes for a second. It's not 1 or 2 cops at the door. It's 11. 11 armed officers coming into your home. They wake you up and they tell you to get out. I mean, can you even imagine how terrifying that would be for anyone, let alone a 19-year-old who's never dealt with this before?
And this whole situation brings up a super important legal idea called psychological detention. This isn't about being physically restrained, with handcuffs. It's all in your head. The real legal test is, would a reasonable person in that exact same spot feel like they could just say no thanks and walk away? If the answer is no, if you don't feel free to leave, then legally speaking, you're detained, even if nobody ever says the word.
So how does a court actually decide this? Well, there's a test for it called the Grant test. It's basically a 3-step checklist. First, they look at the circumstances of the whole encounter. Was this person being singled out? Second, they look at how the police acted, their language, where it all happened, how long it took. And third, and this is so important in this case, they have to look at the person themselves, their age, their race, their background. All right, let's jump ahead 3 weeks. It's now April 7th. Lafrance is officially arrested for murder. He gets taken to the station, he has a quick chat with a lawyer from legal aid, and then he's put into an interrogation room. And this is where the second big legal problem pops up.
So he's in this intense interrogation for hours, the pressure is really building, and he asks for something. He asks to call his dad. And his reasoning is heartbreakingly simple. He says his dad is his only chance of getting a lawyer. He even tells the officers that the legal aid lawyer told him he should get a proper lawyer before he keeps talking.
And what did the police do? They shut him down. Flat out refused. Their logic was, hey, you already had your one call to a lawyer, the legal aid one. That's all you get. They basically tell him he misunderstood the advice, and then they just keep pushing with the questions. And it's not long after that he confesses.
Now, normally, yeah, one call to a lawyer is all you're guaranteed. But there are some important exceptions to that rule, known as the Sinclair exceptions. You might get a second call if the police want you to do something new, like a lie detector test, or if the charges against you change. But the big one for this case is the third exception. You get another call if there's good reason to think you didn't really understand what your lawyer told you the first time.
So you've got these 2 huge legal questions on the table, right? Was he really detained back on March 19th? And should he have gotten that second call to a lawyer on April 7th? With all that in the air, the case goes all the way to the Supreme Court. And when it got there, man, the judges were split right down the middle. The final vote was 5-4. I mean, it doesn't get any closer than that. This just shows you this was not an easy call. We're talking about a major disagreement between the country's top judges on a fundamental question.
Where do you draw the line between the power of the police and the rights of an individual? So let's break down that split. On that first question, was he detained on March 19th? The 5 judges in the majority said absolutely yes. They said you have to look at the total picture. For someone like him, young, indigenous, woken up by a tactical team, words like "you're free to go" are pretty much meaningless. But the 4 judges who disagreed, the dissent, they had a totally different take. They said, look, the police told him he could leave, they didn't force him, he chose to cooperate. And that same 5-4 split happened on the second question too. The majority said, yep, his right to a lawyer was breached. They saw his confusion as a clear signal that he needed more help. The dissent once again said, nope, he understood his rights just fine. So with the majority winning out, they made a huge call. The confession gets thrown out completely, and they ordered a whole new trial.
Okay, so a new trial for Nigel Lafrance. But what does this mean for the rest of us? What's the bigger impact here? Well, this ruling is a really big deal for how police have to handle situations, especially when they're dealing with vulnerable people.
The reason the court tossed out the confession is because they said using it would bring the administration of justice into disrepute. That's a powerful line from our Charter of Rights. Basically, they're saying the way the police got the confession was so wrong that to allow it in court would actually make the whole justice system look bad. It's a huge statement that how you get evidence is just as important as what that evidence is.
So what are the big takeaways here? 3 things to remember. First, context is king. You can't just listen to the words police say. You have to look at the entire situation. Second, a person's identity matters. Their age, their race, their experience with the law, that's not just flavor text, it's a critical part of the equation. And third, the right to a lawyer is about real understanding, not just checking a box for one phone call. Police have to be on the lookout for when someone is confused. And all of this really leaves us with a huge question, doesn't it? The Lafrance case perfectly captures this ongoing tug-of-war in our justice system. On one side, you have the need for police to investigate and solve crimes. On the other, you have the duty to protect the rights of every single person, especially the most vulnerable. This 5-4 split just goes to show how incredibly hard it is to find that perfect balance, and just how important it is that we keep trying.